Tamekloe, who is acting CEO, DMPA, Director Legal of the National Democratic Congress. Thank you very much for your time. Good morning to you.
Good morning, and good morning to your cherished listeners and viewers.
I hope you're well.
By God's grace, I have good health. Yeah, most important.
But let's start with some education for those of us who are not lawyers. When you bring an injunction of sort, an application for injunction of sort, there were people who says that injunction application alone should have served as an injunction. That was what the Chief Justice was arguing, that should have stopped the committee from continuing with its work. Exactly what was the Chief Justice supposed to prove to get that injunction that he was looking for?
Usually... Hello?
Yes, we can hear you.
So, usually what happens is that there are two schools of thought.
Okay.
That an injunction having been served on you, you're automatically forbidden from doing the thing that the injunction seeks to, unless it is determined.
Okay.
Then there's another school of thought, but it is not exactly the case. You understand?
So there are two different schools of thoughts on what the Chief Justice was saying. That's
two schools of thought.
Okay.
One says that you should not do anything to undermine the administration of justice.
Okay.
At all. Mm-hmm. Don't take any steps to undermine the administration of justice. And so once you take any further steps, that would amount to contempt of court. So that's one school of thought.
Okay. But which of the schools of thought has the Supreme Court tended to uphold?
It depends.
It depends.
Yes.
What are the conditions?
Purely to the discretion of the judge.
Oh, okay.
And the circumstance. I mean, the court's attitude towards this thing. I'll give you a classic example. If you recall, when the Electoral Commission decided to do the limited registration exercise September 2023, you remember I was lawyer for the NDC.
Yes.
We served the injunction on the Electoral Commission, the application. Finally, when the date was given, we were given 17th October, even though the EC was acting in September. You understand? So that's basically, they proceeded, even though the injunction was fixed for, So sometimes, as somebody would say, it's complicated.
But is that not confusing? Why wouldn't there be a stated position that guides the conduct of lawyers? So if you're a lawyer and you're advising your client as to whether to continue to do something in the face of an application for injunction, what would be your advice?
No, if you can repeat that.
No, so let's assume, because you're saying two schools of thoughts apply,
Yes.
Depends on the circumstances. So you are a lawyer, your client comes to you. There's an implication of for injunction, something that he is doing. He asks you a simple question: can I continue? What would be your advice?
As somebody, we lawyers usually use the word, it depends.
It depends.
We use the word, it depends. Sometimes, depending on where you find yourself, it tells you what advice to give.
I see. Anyway, because I realized the Chief Justice was actually urging that on the courts. But anyway, the court threw out that supplementary affidavits. I don't know. The reasoning of the court on that matter, what do you make of it?
Yes, you see, Sena, the thing with this that you are always invited to exercise testimony. You understand? It's
Okay.
always an invitation for you to exercise caution. And that is why it is said that an injunction application, for instance, is discretionary. But the specifics, you see, you file an injunction for application. The application itself must be anchored on the substantive action.
Okay.
Here, what is that substantive action? The substantive action is the writ that was issued in the name of now suspended Chief Justice. Are you okay?
Yes.
Now, the last time I shared with you, what is the relief one?
I'd have to go back to the original. I don't have it open yet.
The relief one has to do with the fact that the Chief Justice accepts a right,
Okay.
that he has the right to be heard in public. You remember?
Yes.
That was the relief one. But you see, the Supreme Court of Ghana has already, okay, the Supreme Court of Ghana has already about almost 30 years ago resolved the matter. How did the Supreme Court resolve this? If you recall, General has appointed a CI. You remember? And the Ghana Bar Association brought all kinds of allegations against him. Hello?
Yes, I'm listening to you. I'm listening to you.
Yes.
Can hear you.
And they had even started, quote unquote, some impeachment kind of proceedings. And they wanted it done in the open.
Okay.
You understand?
Okay.
So the Ghana Bar Association went to court to assess these issues. Now listen to what the Supreme Court said. Quote, it is important to note that Article 1468 of the Constitution provides that the proceedings of the committee appointed to deal with any such proceedings shall be held in camera. It is mandatory that such proceedings be held in private, not in public or open courts, as has been unfortunately done in this case. The reason for this important provision is obvious. It is to preserve, protect, and safeguard the authority, dignity, and independence of the judiciary. It will be a sad thing for this country if these courts were to grant the request of the Plaintiff Association, Ghana Bar Association, and start removing our judges in open courts, contrary to the provisions made in the Constitution 1992 for that purpose.
Okay. So this was a decision. Okay.
Of the Supreme Court.
Days back to the 90s?
Over 30 years.
Okay.
No, sorry. Almost 25 years ago.
Okay.
And incidentally, the plaintiffs were the Ghana Bar Association. Do you get it?
And that was the position of a court on it.
Yes.
That this is a matter that's supposed to be in camera, is mandatory.
And the court said there's a policy reason to protect, preserve the dignity and the independence of the judiciary. So when you suggest that no, don't do it that way, do it differently. In fact, the decision was in 1995. How many years now?
That's 30 years.
Exactly 30 years.
Yes.
So you see it in the 1995-96 One Ghana Law Report at page 590. And you know the interesting thing? Justice Ajabin, who was on that panel, then proceeded to add. He said, the reason for this is not far-fetched. It is to preserve, protect, safeguard the authority, dignity, and independence of the judiciary. Now he proceeded. It is in the light of these observations that I consider this action of the plaintiff association, who should be expected to know better, most unfortunate, as it is likely to undermine the judiciary in particular, the rule of law in general.
So those judges did not take kindly to even a suggestion.
No! Even when the Ghana Bar Association initiated this process, the Supreme Court said, look at you, an association of lawyers. You are supposed to even know better.
I see.
You are rather before us, urging us to do contrary to the Constitution.
So that was why the court was of the opinion that the matters contained in that affidavit are matters that are not supposed to be in the public domain.
No. Look, let me tell you. And this provision, the Supreme Court doesn't joke with it too. Look, a bit of history. Around 2005-06, you know the respected lawyer, Bright Akwesi?
Yes, very well.
Good. So Bright Akwesi came out with a petition against Chief Justice Akwa. I don't want to repeat. Then the petition to President Kufuor found its way onto the front pages of either Enquirer or so. Our Raymond Archer's Enquirer.
Yeah, the famous one. Yes, I remember.
Good. Raymond Archer, David, Tamekloe, and Co. So when they found its page on the front page, the president was in the process of initiating the impeachment proceedings against Akwa. Then a young man by name Frank Ajetu went to the Supreme Court and said, hey, something untoward had happened. The Constitution says in Article 1468 that all the proceedings should be held in camera. That in camera proceedings, which refers to Superior Court judges, applies to the Chief Justice as well. Because the Chief Justice is first a Superior Court judge before having the additional writ. And to the extent that the Bright Akwesi petition had found its way onto the front pages of newspapers, the petition being the root of the impeachment process, everything is unconstitutional, null, and void. And that is how the impeachment process against Chief Justice Akwa was started. It is in our law report.
So in the two cases where this matter of making a hearing under Article 146 public, or even the step taking that they saw as putting out the details,
yes,
the Supreme Court has always held the opinion that it's supposed to be in camera.
If you recall, when Her Ladyship the Chief Justice demanded of President Mahama copies for her initial response, you remember?
Yes.
The communication to her, the president stated that they were going to mark the pages. You remember?
Yes.
They were going to mark the pages, so that if you leak it, it will not be used. You cannot now rely on the leak to say that the entire process should be declared unconstitutional. Sarah.
So what because this is part of the substantive case of the Chief Justice. The Chief Justice
Yeah,
is
but you
asking.
see, an injunction is predicated on a substantive matter. You can't file an injunction if there is no the substantive right.
Okay.
And so, in deciding whether to dismiss or grant, you must first go to the root and see whether the case that the person has brought is even sustainable. And like I just read, the Supreme Court, as early as 1995, had taken the view that the reason for the in-camera proceedings is to protect, preserve the authority, dignity, and independence of the Supreme Court.
So,
and if you listen to the Supreme Court judges, the first one I read was Justice Berger. And his Lordship Justice Berger says, look, to accede to the request of the GBA, it will be a hard day. These are very serious words. In fact, in the words of Justice Ajabin, JS, he even said, the GBA, being an association of lawyers, should really know better and more or less not to engage in this constitutional lawlessness. That is how the Supreme Court has taken strong views on Article 146.
I see. And you're also suggesting that to come to a conclusion, a decision on an injunction application, the Supreme Court also has to make, not so that I'm not held in contempt, a fleeting verdict on the substantive matter itself.
It's a balancing act. So you weigh and say, this relief 2 or relief 1, the thing the person is asked, plus or minus, is it something that we can even entertain? Are we not going to go against our own decisions? Are there policy grounds? Because you see, the Supreme Court can depart from its previous decision, right?
Yes.
But in doing so, there must be a strong policy reason. And where previous Supreme Court judges say that the reason for a provision is to protect, preserve the dignity. So it is not personal. It's everywhere. When I say it's not personal, the provision was not put in there because we anticipate that there will be a talk on it today. Do you get my point? It has been done for a bigger policy reason beyond the person occupying the office. And so, if, for instance, as alleged in Relief 1, the suggestion is that the Chief Justice has a right. First of all, like the Supreme Court decision, they said the provision is mandatory. Mandate, obligation, a duty. It is not optional. It is not an option. When there is an option, you can waive. When there is a right, you can waive the right. Except that there are certain rights that you can't waive. For instance, the right to life. You cannot say you are waiving your right to life, except a court says by reason of a sentence for committing a crime, you are sentenced to death. That's a waiver of the right to life. Do you get it?
Yes.
At this point, you don't have a right to be heard in public because Article 1 4686, or the proceedings must be held, shall be held in camera. In camera, from the Latin word in camera, means hidden, secret, not public. It is like in chambers, out of sight.
Okay. So then I go back to because this is also in a substantive matter. There are decisions in the past on it. But we do know that the Supreme Court can declare a constitutional provision unconstitutional, and they can depart from their own decisions.
No,
Okay.
you can't describe a provision to be unconstitutional. You cannot.
Okay. So what can they really do here?
No, so you are permitted to describe an act that it does not accord with the Constitution.
The act.
An act being done does not accord. Now, what is that act? That act is that she has been invited to appear before a committee investigating her based on a petition after a prima facie case has been decided, right?
Yes.
Now, the Constitution says that that proceeding should not be done in public, right?
Mm-hmm.
Then now she comes and says, no, I, so and so, I have the right to be heard in public, contrary to the express words of the Constitution.
Mm-hmm.
Do you get it?
Yes.
But like I pointed out, this provision has already been adjudicated upon in 1995, 30 years ago.
But you also say the Supreme Court can depart from its earlier ruling. I agree with the Chief Justice. Can they?
No, you see, that's why if you listen to me carefully, I say that the Supreme Court can depart from its legal decision. Right?
Yes.
However, when they are doing so, there must be a strong policy reason.
Okay.
But in this particular case, the policy reason for this provision is that it's a provision meant to protect the authority, the dignity, and the independence of the judiciary. So why would anybody want to do contrary to that? Are the judges not interested in protecting the dignity, the authority, the independence of the judiciary? Certainly that should be their number one priority. Or
And you're saying that this is not only how the Chief Justice do, it's about any decision they make now will affect them if they face the same issue.
All superior, and that is why Justice President said, it will be a sad day. It will be a sad day in Ghana that superior court judges will be removed in open court like we are having a theater. No.
Anyway, I think earlier we had a quite a lengthy discussion on this. So anyway, they will now hear the substantive matter. But let me go to what Godfrey Adami said. He keeps going back to the issue of the prima facie determination that the Chief Justice was supposed to know on which particular allegations the prima facie determination was made. The reason they had arrived at that conclusion and they suspended it, that it was a right to know. And that is one of the things they are urging on the court.
Rights are not controlled. Rights are conferred.
Not conjured, conferred.
You say?
Rights are not conjured, they are
They are
conferred.
conferred. So that is why the 1992 Constitution has an elaborate provision and a whole chapter on human rights. Do you get it?
Yes.
So that it takes so the Constitution, right from Articles 12, 13, 14, up to 33 They are all on human rights. The right to this, the right to that, the right to this, the right to this, the right to this. Different kinds of rights. And the Constitution even says that even the rights that we have mentioned here, they may not be exhaustive, but rights that are called with democratic society, we are going to contemplate that. So first, the Constitution itself must confer. And you know the curious thing, the Constitution itself has also provided a mechanism and a forum for ventilating human rights. Correct. It said the High Court shall have set jurisdiction to enforce fundamental human rights. It's in the Constitution. Article 33 confers that right to the High Court. So, assuming that the assertion is that she even has the right, is the Supreme Court the proper forum? Huh? So that.
But there's been times when the Supreme Court, that argument has been made, and the Supreme Court has still decided to go ahead and hear the issue.
No. There are only instances where the assertion is that there are certain rights that go beyond it. So, for instance, in Nana J. Ampofo versus AMA, right? Nana J. Ampofo had brought a case, former Gwosomani, had brought a case against Accra Metropolitan Assembly, right? And the Attorney General. What was his contention? He says, look, the Constitution says you have right to dignity, to be treated properly. And that phenomenon, then within the Accra Metropolitan Assembly, where human beings were subject to the removal of human excreta, it is well in the morning. My apologies. Okay?
Mm-hmm.
You know night shore?
Yes, I know.
What we used to call night shore harriet. So Nana Jampogo went to court and said, no. The right to dignity is constitutional. And so that thing AMA read together with a constitution that's not. So the Attorney General then raised an objection to the fact of the Supreme Court. Then the Supreme Court asserted that, you see, this right that is being asserted is not to an individual. You get it?
Mm-hmm.
It is not like somebody who carries knife or is the one who brought the action. It is the dignity of all other persons. But you see, in this case, the plaintiff asserts a right, that she has a right, and that she is waiving that right. So she is asserting a right. So the Constitution says that a person who alleges that his right has been threatened or is about to be infringed upon, the person can bring an application at the High Court for declarations and what has to that effect. That's not what is happening in.
See. Well, he said he's doing all this because he believes that due process, constitutionalism, rule of law
But
must
is it not the
ultimately.
Constitution that says that it should be held in camera? Is that not the rule of law? In fact, the case I read, Justice Agaben says that the reason for this is to protect the Constitution and the rule of, he said the Constitution specific, the rule of law in general. So, unless I don't understand what that means.
Well, I'll conclude on another question, but before that, I just wanted to take your attention to another matter shortly. It's a matter of Chairman Wuntumi currently at Yoko. We understand Yoko has offered him, so the bail that has been offered him is 50 million, two sureties to be justified. Explain to us what that means and why that is usually difficult.
Oh, you see, for some obvious reasons, I don't want to comment on it. You see, because for the past 8 years, I have been involved in some of these high-profile criminal investigations and prosecution. A bit cautious when it comes to these conversations. My view on this matter is not be greatly well received. So I'll tell you a story.
Okay.
So, myself and my senior attorney were lawyers for Dr. Dufour.
Okay.
So we were invited one day upon receiving charges to appear before court. Right?
Mm-hmm.
So look at Dufour, a man who has served this country well. Deputy governor, finance minister, the owner of the business, a respected man. He has served this country well. So we had appeared before the court. After everything, we said we are not guilty. And Dr. Aiden Middleman applied for bail. So when we applied for bail, and this is Dr. Dufour, who has been served with charges for almost a week before we finally went to court. Right?
Mm-hmm.
So we prayed for bail. The judge said, so I'll grant you the last offer. And I remember the lawyer who was there. So the judge granted us, you know the sum,
No, tell me.
100 million to be justified.
100 million cities.
To be justified.
Whoa.
Look, me, I started sweating. Huh? Senna? Me, I started sweating.
When you had 100 million?
Yes. I said, look, this elderly man. I went to him at home and said, as your lawyer, you go to court. With who you are, you have a house. You've lived all your life in Ghana. You only school and came back. After 70-something years. This is how the Republic wants to treat. So, we should be able to do self-recognizance bail. You know self-recognizance?
No, explain that.
No, self-recognizance. Looking at who you are.
Okay.
A court can say, oh, you, on your self-recognizance, go and be reporting to the police. Englishman, Dr. Dufour, for Christ's sake. In the 90s, the man was deputy governor, became the governor of Bangkok, became Ghana's finance minister, the owner of several businesses, insurance, banking, mining, everywhere. You get it? But we pray for the self-recognizance bill. The judge said, no, I'll grant him the bill all right, but I'll peg it at 100 million.
And when they say it's to be justified,
you need to have a landed property to having that same value.
Oh, property or properties? Can it be more than one?
It should be property.
One.
But the point is that the value should be up to 100 million.
Hey.
That's all.
I see that. That's a tough one.
Look, that day, I'll tell you a story. Usually for those matters, when I go with my seniors or Tiny and his dad, you pick his wig and gown. He has a bag, then you put it. Then so, ODG, deal with the other administrative matters. That's the execution of the bill. I was there with Dr. Dufo at the court registry. Bro. Time sometimes shortens your pay. So I started running, helter skelter. This old man, I come to court with him from home, and he can't go home. Hey, what am I going to tell the wife and children? So thankful. So something happened. We then made a further prayer to the judge. So we moved to Madam Gloria to say, so Madam, put in a word there. Look at Dufo. This man has served Ghana well.
Okay.
So we said, okay, let's pray to the judge to review the order. Then the judge said, okay. After making copious prayers, the judge said, you are review it from 100 million to 65 million Ghana cedis.
That is after Gloria Kufuor had also put in a word.
No, Gloria says she won't oppose.
She won't oppose?
Yes.
Okay.
Our application for review to leave it from that.
From 100 million to 65 million now.
So from 100 million, the judge then got it. So, oh my Lord, this is technically a refusal. You understand? It's technically, you see, their judges don't impute anything. The person will grant you bail. He doesn't want to be on record as refusing you bail. But the bail conditions alone will tell you that it's a refusal. It's an implied refusal. Do you get my point?
Yes. I see.
So, I remember, thankfully, I started making calls, and with the support of other seniors, Dufo's elders came around. I think he manages that assurance or something. He came around, and they brought the Star Assurance head office building document, and that building should be more than this is something $1 million. Ghana cedis.
Okay.
If you look at the dollar equivalent.
Okay.
Thankfully, we brought a registrar, wherever it is. I want to thank him, Afute. He used to be at the commercial court. So, look, I'm in his bed. That night, he waited, investigated here and there before finally we were able to meet the bail condition. So that day, I left the court complex with for after 8 years.
Wow.
Yeah.
So from what you're saying, this is implied in the bill that they've granted to Untumi is the people in Yoko telling him that we really like to hold you for a while.
No, you see, the one I'm just talking to you is a court one.
Okay.
At this point, investigations and everything have ended. The matter is in court. This one is at the point of investigation. Sometimes investigators will be afraid that, oh, you know what? This one, if bail is granted, he can easily go and compromise potential witnesses.
Okay.
So it comes in varied forms.
Well, I said I was going to conclude with a question. I know you've been in a matter where Godfrey Ebu Adame, your senior Tadio Sorry, and yourself have all been in that issue. Whenever you are looking at the two of them, do you see a stir of jealousy from Tadio sorry to us, Yebo Adami. Like he always stares with hot jealousy.
Oh, I have known the two of them pretty well. I know Thaddeus very well. Look, Thaddeus that I've always known, plus or minus, I would even say he's even pro MPP.
Really?
Hello, Senna.
Really?
Yes.
He's.
So let me start from here. You see, his people master was Ambrose Derry. You know Ambrose Derry?
Yes, very well. Former Interior Minister.
So for a long time, he was in Derry and Co. You remember Malamisa?
Yes, sports minister at some point.
So that Malamisa criminal trial, you know Malamisa's lawyer was Ambrose Derry. So it was Thaddeus and Sini Ambrose who conducted the case for Malamisa. Right? Okay. Let's put that aside. You remember in 2008, one of the major campaign message of President Mills, his soul rest in peace, was to find the perpetrators of the killers of Issa Mobila, the CPP regional chairman for Northern Region, who also happens to be a transport owner. You remember?
Yes. Good.
The man who was murdered, whereupon they tied him upside down, beat him until his lungs collapsed. Right? You remember? So in 2009, when President Mills became president, he carried through with that. So it was investigated, and 2 soldiers were arrested and prosecuted. Do you know who their lawyer was?
No.
Thaddeus. Thaddeus. For a long time, he was lawyer for Obiamwa. When under President Mills, there was some investigation involving him. If you recall, in 2009, the then Union Fraud Office, now called EOC, stopped the offices of you remember? You remember that incident?
2009.
Yeah, 2009, 2010. SFO was now called Yoko, went into the offices of DFA, took computers and others that they were investigating.
Yeah.
Good. Who was the lawyer for DFA? Was it not Tango, sorry?
Yeah, in fact, for a long while.
So how suddenly, conveniently, do you say that such a person is an NDC lawyer? What I know, and in fact, Ghana, you remember Ghana?
Yes.
The lawyers for Reku Gobe and Kojo Pini were my lord Kulendi's law firm at that time when he was in private practice. Thaddeus worked with Kulendi on that matter. I know Mr. Sorry very well. He is brutally frank, and it doesn't matter. He's a consummate professional. But I can understand where Dami may be coming from. Because from 2017, when the NCA criminal matter came up, you know, the then board chairman of NCA, Mr. Sorry was a lawyer.
Yeah.
Right?
Yes.
And I happen to represent the then DJ, the former DJ, Mr. TV. So I want to believe that is why suddenly Godfred has forgotten all the matters Mr. Sorry has done in the past and want to paint him with an NDC brush. I think it's unfortunate and mischievous.
Thank you. Thank you very much for speaking to us.
Have a blessed day. And my regards to your colleagues.
I particularly enjoy your story on representing Dr. Dufo. Anyway.
Oh, you didn't know about this?
No, not really. I didn't know. Well, like God, the EDUDZI Tamekloe is Director Legal of the NDC, CEO, acting CEO of the National Petroleum Authority, join us on the line. We're talking about